Hey everyone, Harry here, and I'm back. Thanks so much for the guests who really picked up the slack when I was gone feeding you analyses of the current news, and there was a lot of it. Today I wanted to talk about Donald Trump and his big mouth as it concerns two cases where gag orders might be in the air. The January 6th trial in front of Judge Tanya Chutkin and the AG fraud trial currently going on in front of Justice Arthur Engoron in New York State Court. They're both important in different ways, and there's some things that I think people haven't quite picked up on. Let's talk about the law first in the Chutkin situation. So you'll recall the bidding. She gives him a gag order. And it says, look, you cannot do anything that would target Jack Smith or court personnel or any reasonably foreseeable witness. Makes sense. One goes to just what Trump likes to do, and also it goes to the two lookouts for Judge Chutkin here: the integrity of the trial and then the safety of the witnesses, which amazingly enough is at issue because it's Trump on the hustings with his threatening type language. Okay, so the focus has been legally on her use of the word to target. And the ACLU actually came in, the avatars of liberalism and the First Amendment, saying it's unconstitutionally vague. You're doing a prior restraint here, keeping him from talking before he talks. And in the time-honored way of the ACLU, who also recall famously supported the right of Nazis to march in Skokie, they're saying, it's unconstitutional. You have to tighten it up. But of course, tightening it up means loosening the reins for Trump himself to make trouble. Would he make trouble? Yes, because the second point here that's been really telling is he has basically pushed on or jumped over all borders that have been set in both cases. So Judge Chutkin said, okay, I'll suspend my order while you appeal it to the DC Circuit, and Trump proceeded to absolutely run roughshod over it and totally deliver a diatribe against Mark Meadows when we learned he had testified in the DC grand jury and spoken to prosecutors that Judge Chutkin said clearly would have violated the gag order. He basically called him a liar, saying, he said stuff that wasn't in the book. And he said he never told me this or that, which could have been taken as a possible effort to obstruct or shape witness testimony. Way, way, way out of line in classic Trumpian fashion. So Judge Chutkin reinstates the gag order and doesn't change it, doesn't tighten up the language for target, etc. And just today does a pretty remarkable thing. Well, really not so remarkable, but the ACLU had filed this brief. She said, I'm not going to accept the brief, which you would think, why would a judge not accept the brief? What's the big deal? But, it's something that's rarely done in the criminal setting. And she said, there's no special reason to do it here. The issue, however, now comes up, and we'll go to the Court of Appeals. So Trump, given an inch, took a mile, just totally dumped all over Meadows in a way that plainly would violate any gag order. And she reinstates the gag order, and it goes up, and the argument will be, as the ACLU supported in the brief that she didn't receive, this is vague. I think they're wrong about this, and the DC Circuit will tell them they're wrong. I think basically ACLU has done some great things for this country. Don't get me wrong. My mom was a longtime executive board member, but man, can they get nutty on the First Amendment. And I think they're just confused here. They're basically saying you need to think about a gag order like you would any prior restraint on speech. For example, an order to a newspaper not to publish something, and you have to have all kinds of very stringent justifications. I think that's just wrong. This is a different category because this is not the government discriminating based on the viewpoint or the content. It's rather, this is the government doing a different thing, which is safeguarding the integrity of a trial, protecting witnesses. That puts it under a different rubric than the normal prior restraint rubric. It's plainly a compelling interest for them to do, and that means Chutkan doesn't have to get it exactly right to the nth degree, but rather can make a generalized kind of holding that says, look, we know it well enough when we see it. Don't go after any reasonably foreseeable witnesses. How the hell hard is that? So now it's going to go up on appeal. I think it'll be sustained. So where are we with Chutkan? Well, kind of back where we were before. So here's what I've been saying from the start. Nobody wants to put Donald Trump in jail. Well, nobody in this, no judge wants to, probably no political figure wants to. The one person who's the big exception here is Donald Trump. Is it really the case that he wants to flaunt things so much that he goes to jail to get sort of wear a martyr's robe and show, here's how he's being punished for you, my voters? Because if he wants to, it's going to happen because there's, he just can leave her no room. And as soon as I say he got an inch when she suspended the order, he took a mile. And she now, if you sort of see it from the very beginning, when he comes in as a clean defendant to the time where he would have to go to jail, he's really burned about half that rope. And Chutkan has now made it clear you violated the order. Let's say he does it again. I don't think she's got all that much room to play with. She can, a couple stern warnings, maybe a financial penalty like Engoron has done in New York. We'll get to that in a second. But, there's going to come a time where she says to him, look, pal, if you do this again, that's contempt. I'm going to put you in jail. That point has to come, that final point where everybody knows it. And then if Trump is looking to do this for some, political benefit, that's it. The system will have no other recourse. It's pretty clear that if he had just done, any other defendant had just done what he's done so far, they would be in jail. They would have pooled his conditions of release. He's on release by the grace of the state, but subject to certain conditions. And if he flouts them so flagrantly and in a way that so endangers the integrity of the trial, he's playing a game of chicken. He wants to play a game of chicken. If he wants to go to jail, he's going to go to jail. All right, let's go over to Engoron now, where we already know this is the trial that's going on, and where Trump made a threatening comment and a false one about Engoron's law clerk, suggesting that she was all like buddy, or even worse with Chuck Schumer. Engoron came down on him hard, or at least quickly, not so hard, gave him a $5,000 fine, said take it off right away of Truth Social. He did, but he didn't take it off his campaign website. So he said, oops, it was just a mistake. Sorry, Justice Engoron. And then he fined him another $10,000. So he knows that that's happening, and he complied, did Trump, with the order involving the clerks. But now what's going on? Since he's been compliant, all of a sudden he comes out with this huge diatribe against Engoron, who he calls unhinged and dangerous. I mean, really, way, way beyond the pale. What is the deal here? Isn't he just saying, please, please, Justice Engoron, throw me in jail? And this is the case, by the way, that is hurtling toward the conclusion where Engoron is going to make the findings. And we have, after starting late today or tomorrow, the four Trumps to testify, and that's the end of the trial. Here's my take on this. He knows he's going to lose this trial. He knows Engoron is going to clobber him, and he knows it's all going to happen in short order. So there basically isn't enough time for Engoron to throw him in jail. The whole thing is going to be done within a week, and he knows Engoron is going to totally pummel him. He's looking at a big and bad verdict. Remember, Engoron already took the main issue about fraud off the table, saying it's been proven against Trump. We know he's already guilty there. So it's just what to do with these other sort of 6 causes of action. He's going to clobber him. And Trump sees that. And now he's got, in a way, no downside to totally trashing him. It makes his supporters, buoyant. Yay, Trump going after the elite. It sets a little bit of an atmosphere of I'm being, that may help on appeal, that I'm being, targeted or prejudiced by a judge, being railroaded. And basically he's going all in, even though it's flagrantly in violation of, there's not even a standing order in the Engoron case, but you can't say crap like this about a judge. He knows it, but he knows it will play out more quickly than will permit this whole long thing, as could go on in the Chutkan January 6th case, which has several months till it starts. So here what's happening is he's trashing him because he won't have additional penalties, really, because it's about to go to the fact finder, being Engoron here, and you can look for Trump to be absolutely pummeled in the opinion that Engoron as fact finder issues. Okay, so Donald Trump and his big mouth. In the Chutkan case, is there a constitutional infirmity? I don't think so. And when the Court of Appeals says that, we'll be, from this much, he'll have burned about half the rope, and there's not all that much space between him and jail, and it'll really be up to him. How much does he want it? In the Engoron case, he's being completely out of line, but he knows basically there's nothing, the gig is up there. He's going to lose the case big. There's not enough time for him to really have a big showdown with Engoron, so he does it anyway. So there you have it. Donald Trump and his big mouth and gag orders, going to be a live issue in Chutkan, not so much in Engoron, which is hurtling to a conclusion, and a very bad one. Not jail, but a lot of money for Donald Trump and the Trump Organization, probably sometime next week. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.